Great. Good morning, everybody. I've been given two challenges today. I've got 5 hours worth of talk to cram into 25 minutes, and I've got to make legal stuff interesting on a Saturday morning. So forgive me for trying my hardest with legal stuff, but I'll try and give you something at least to go away with. So what we're talking about today and this morning is about succession planning and making sure that your child is protected and making sure that any vulnerability there is safeguarded. So I'm going to hopefully give you some tidbits. We're going to look at some wills, trusts, court of protection stuff, just to give you an overview of everything. As Sarah said, this afternoon I'm doing some more clinics, so if you need any more information, then come and find me this afternoon. So in terms of Renaissance Legal, we are a solicitors firm. We're actually based in Brighton, and I know some of you here today are our clients already. We've got offices in London Euston, in East Croydon, and in Crawley. We're a specialist law firm, so actually we only do this type of work. We work with families to make sure that people who are vulnerable and disabled are protected, be that your children, siblings, or your parents. And we work with lots of local and national charities to make sure that the information is out there and really to empower you to make decisions to do the best for yourselves and for your family. We're the legal advisors to MenCap, so we work very closely with the Wills and Trust team at MenCap. And as Sarah had on her last slide, we actually also work with Scope and with NAS as well. Just really making sure that all of the legal information is out there to you guys. So again, if you need anything, like Sarah said, information-wise, we can direct you to the legal resources. So we're going to take a whistle-stop tour of a will. We're going to have a look at the exact type of trust that you might need to set up. We're going to talk a bit about mental capacity and what you need to think about when we're talking about mental capacity in a legal context. Then we're going to have a look at what the Court of Protection does, just in case you need to come in contact with them, and then look at a family scenario and see what a typical family might do, and then just give you a bit of an idea about what we're doing this afternoon. So the starting process really is to think about why are we all here? You know, what's common to us all here? And actually some general principles, some general misunderstandings, and kind of get you focused on where we need to head. So I guess the starting point for me is to, as a family and as parents of children with BBS, is to get you thinking about why you shouldn't actually leave an outright gift to your child with BBS. So that's a question to you guys. There's kind of 3 main core principles why you wouldn't do that. So open it up to the floor and give me some suggestions. Yeah. Brilliant. Okay, so we've ticked off number 1. So number 1 is that means-tested benefits, so not your DLA or your PIP, but things like housing benefit, income support, some of ESA, they're means-tested. And largely speaking, just as a sort of general rule, if you have anything more than £6,000 in your name, the means-tested benefits are going to be compromised. So one of the main reasons why you as parents won't want to be leaving money directly to your children is because you need to preserve the means-tested benefits. Yeah, any others? We've got 2 more. Come on, we've got a big room of people. Yeah. Brilliant. Okay, we've actually ticked both the other boxes. So what we've got there is a child going off to Bermuda for 6 months. So what we've got is we've got the potential of someone being vulnerable. Okay, so vulnerability can be lots of different contexts. You know, we could be vulnerable if we were a bit inebriated last night. Some people might have had a few too many drinks in the room. So we have a vulnerability, but also we have capacity-related issues. So when we come on to talk about capacity, we'll see how that is affected in a legal context. So we've got 3 principles here. We've got the situation that actually we want to preserve means-tested benefits. We've got someone who is possibly vulnerable, and we want to make sure that that vulnerability is not actually increased by leaving them our assets. And what we want to do is make sure that if we've got a child who has capacity issues, we're not compromising those capacity issues, making them worse, because actually if they have capacity issues, it may be that we can't leave them our assets in any case because they don't have capacity to manage it. So that's our starting principle, really. When we're looking at succession planning, we're saying, okay, you may tick all 3 boxes, you may only tick 1, but actually whichever one you tick, or more than 1, we need to just make sure that we don't give our money directly to our children. So the next thing is, having kind of decided that and knowing that we're not going to do that, what often happens is that families come to us and say, okay, well, we've actually got 2 children. And what we'd like to do is, instead of leaving everything to the child with BBS, having heard your talk, we'll go and leave everything to the child that doesn't have BBS. So let's say I've got two children. I've got Zach, who is 18 and he has BBS, and Chloe, who is 20. I rock up to my lawyer and I say, okay, well, I know I shouldn't leave anything to Zach, but actually what I'll do is I'll leave everything to Chloe. I then pop my clogs and everything goes to Chloe. So what happens then if Chloe dies? Chloe's probably married. She leaves all of her money to her husband. He goes off. No provision for Zach whatsoever. What happens if Chloe is declared bankrupt? Again, total loss of the money. To take it one step further, what happens if, having inherited all my money, Chloe's husband then decides to divorce her, and, as a general principle, he runs off with half of her wealth. Again, no money to Zach. And then we can't account for family fallouts. So if later on Chloe and Zach fall out, Chloe's got all of the wealth, she goes off, again, no provision for Zach. So on slide 1, what we're saying is we don't want to give anything directly to our child. And on slide 2, what we're actually doing is directing you to say, actually, trusts are going to be the answer. We're not going to leave it to anyone else to sort it out for us. We're actually going to take control and take ownership of what the situation is, and we're going to put a trust in place. And then following that thought process through, having said, okay, we're going to do a will, we're going to set up a trust, when that's done, we also then need to think about, do we need to protect our child any further? So do we need to protect our child by our child doing a power of attorney, or do we need to think about whether we need to ask for the Court of Protection's help? And I'll talk to you about that a bit later on, and also a bit more this afternoon. So, we've said we need to make a will. Who here has a will? Pop your hand up. So the first slide is going to relate to a lot of you in the room, okay? Because the first slide is going to say, what happens if you do not make a will? And that means that there's probably half of you in the room that are going to squirm when I tell you what the answer is. And so there's some funny faces being pulled at me already. Okay, so does anybody believe that if you don't have a will and you're married, everything goes to your spouse? No, exactly right. And that's why you've got to make a will. So what actually the law says, the law tries to impose, or the law actually does impose, intestacy rules on us. And the intestacy rules dictate what will happen to our estate if we die without having left a will. And what the intestacy rules say is that if you are married or in a civil partnership, your spouse or civil partner will only receive the first £250,000 worth of assets that you have, and then half the remainder. So when we think about the value of property these days, and say, for example, me living in the southeast, unfortunately, property values are extortionate. If I've got a property worth, let's say, 500,000, and I'm married and I die and I don't make a will, clearly my wife doesn't actually get the whole of the house because she only gets the first £250,000 and then half of the remainder. So she gets the value of £375,000. The other £125,000 goes directly to your children at the age of 18, irrespective of vulnerability, of any capacity problems, and irrespective of means-tested benefits. So leaving it to the law, for you, is just not appropriate. If then you decide to make a will, because now you're all sort of turning a bit grey, those of you that don't have a will, you then get choices, because you're actually, you're then making decisions for yourself. So your choices are things like, in a will, you can choose who are the guardians of your children. So this relates to someone who is under 18. You can actually say who takes on the caring role for your child. Now, we know, because we've done lots of research on it, that the thing that stops young parents making a will is because they can't decide who cares for their children. And that is so much more expanded where you have a child who is vulnerable and disabled. However, not making that choice is really dire, because actually, who makes that choice for you if you're not around anymore? Your local authority. Okay, some local authorities are brilliant, some are not. So leaving it to your local authority is simply not an option. So make a will, you can choose who the guardians are for your child. You can then choose who actually deals with the administration of your estate. So choosing your executor, choosing trustees, The trustees are the people who are going to manage the trust. All of those things are all choices that you want to make. So making a will enables you to do that rather than leaving it to what the law says, the law thinks is right for you. And then you can think about the provision for your family. You can think about setting up these trusts that we've talked about. We can think about protecting our children. So for us, doing a will is the first step in making sure that you take ownership of what your situation is and that you make decisions for yourselves to make sure that your children are safeguarded. And that's really fundamental for you. In your will, you have a chance to do some inheritance tax planning. Very topical at the moment because the inheritance tax rules have just changed and they're about to change again. But inheritance tax does unfortunately affect quite a lot of people. And as a general rule, each individual has an inheritance tax exemption on death of $325,000. And then if you are not leaving your estate to your spouse, your civil partner, or to charity, tax is payable at 40% on everything over and above the $325,000 mark. So you are losing 40p in every pound if your estate is worth more than $325,000 and you are leaving it to your children or to a trust or anything other than your spouse, your civil partner, or to a charity. So by doing a will, you also have an opportunity to think about the tax planning side of it. You're then, again, as I said, you're taking ownership of your situation, and then finally, you're protecting your child. So the ultimate thing here is about taking ownership of your situation, making decisions that enable your child to be protected. So we've decided that we want to make a will, and we know what we're doing. The will's nailed, and we can go forward. So the next thing is to have a think about what the trust looks like. And normally, this part of my talk would take roughly about 45 minutes. So I've got 5 minutes to cover what a trust looks like. So bear with me and you will... okay, we've got an old slide. Never mind. Okay, so let me wing it a little bit. Okay. So what we're nailing is exactly what the trust is going to be for you guys. And unfortunately, there was another slide that had a lovely picture on. I'm just going to check to see whether it's there. No, it's not. That had a lovely picture on that showed you what the trust looked like. Never mind. Okay, so for a trust, we've got 3 entities. So we've got the trustees, and they are the people who manage the trust. So being a trustee is purely a job. You are purely doing what the trust allows you to do. When you're choosing trustees, you can have family, you can have friends, you can have professional people, you can have a mixture of that. So the choice of trustees is very, very wide. But your trustees are the people that you are relying upon to do the right thing for you. So that's the first entity. The second entity then are the assets. And it doesn't matter what you put in the trust. Any assets can go in a trust. Largely speaking, any assets can be held within a trust. The only sort of things that you can't have in a trust are things like ISAs, because they're individual savings accounts, so they're not appropriate for trusts. But you can put cash in, you can put a property in, you can put whatever you want in a trust. Equally, whatever goes in doesn't have to stay in its current form. So if you put a property in, it can be sold and it can be converted into cash. If you put cash in, a property can be bought for your child to live in. All of those things can be done. So entity 1 is our trustees, entity 2 is the assets, and entity 3, if you saw the picture, but I've got something for later on if you come and see me, entity 3 are the beneficiaries. So they are the people who can benefit from the trust. And in entity 3, you have to have everybody named who can possibly benefit. So what you generally do, if you go to a really great lawyer, is within that entity 3, you will name everybody you want to have as beneficiaries, but you will also say something like, and any other people who might be co-opted into that bubble at a later date, because you want to create some flexibility to change that. So with any trust, you've always got trustees, you've got your assets, and you've got the people who can benefit. Now, the reason why we go for a discretionary trust, where we're talking about people who are vulnerable, who have potential capacity issues, and where we want to protect means-tested benefits, is that when you're claiming means-tested benefits, the sort of question you look at on the benefits claim form is something like, or the wording is very similar to, do you, the person who's claiming the benefit, have the right to benefit from any assets held in trust? So if you tick yes, then your means-tested benefits stop, and if you tick no, then you're okay. Now, with a discretionary trust, It's set up in a way that the trustees have to exercise a discretion, the trustees up here exercising a discretion over here, to take assets and give it to any of the beneficiaries as they see fit. So in my context, if I'm saying I've got two children, Zach, who is my child with BBS, and Chloe, my daughter, who doesn't have BBS, the trustees are going to exercise a discretion to take assets and to give it to Zach. Now, by doing that, Zach can safely tick the box on the means-tested claim form to say that he does not have the right to benefit from assets held in trust, because the trustees have to exercise that discretion to get assets out and to give it to him. So it's called a discretionary trust. In law, sometimes the words actually do help us, and it's about the exercising of this discretion to take money and to give it to our Zach. What we generally tend to do is put into the trust only what we know is going to be used for Zach. So usually speaking, you would back up the trust with a will, and the will, in my case, would say, when I die and my wife has died, I give a half share to Chloe, because that's my daughter, she gets 50%, and I put a half share into this trust. So I know when the trustees are exercising their discretion, they will always exercise that in favour of Zach. But it's the fact that, in legal theory, they could exercise it at any moment in favour of Chloe that protects that means-tested benefit. Now, it also protects the vulnerability and the capacity side of things, because what the trustees are going to do is make sure that they buy things for Zach. So they're not going to put money through Zach's bank account because he may not be able to manage it, or indeed if he can manage it, it might affect his benefits. But what they're going to do is buy him stuff. So as I said, I live and work in Brighton mainly, and Brighton, as most of you might know, have just been promoted to the Premier League. So one of the things that my trustees might do for my Zach is buy him a ticket, a season ticket to Brighton and Hove Albion. You know, so it's buying him stuff. They might be buying him a holiday and paying for a carer to go with him. So it's buying stuff. So again, it's protecting the vulnerability and the capacity problem because we're not putting anything in his name. So we're protecting our means-tested benefits, and we are providing for our child, as we want them to. We want them to be able to use stuff, but we're providing for them without putting anything in their name. Now, the problem with a discretionary trust is that it is taxed very badly. So I won't bore you with the tax rules because we don't have a huge amount of time. But what the government does is it penalises it for tax purposes. So what the government have done is they have introduced a disabled persons trust. And the disabled persons trust is exactly the same as a discretionary trust. It does exactly what I told you. It does everything that we want it to do. But the benefit of a disabled persons trust is that it is taxed more favourably. So where we have a child with BBS and that child is claiming disability living allowance, care component at middle or high rate, or PIP, either of the two components, then we can upgrade our discretionary trust to a disabled persons trust. And that is a lot more favourable for us because the tax treatment is so much better. So if I explain to you with a discretionary trust, the discretionary trust pays income tax at 45%. Gosh, yeah. Whereas the discretionary trust usually doesn't pay any income tax at all because the tax is deemed to be calculated on the disabled person and they won't have any income. So come and see me this afternoon or chat to me over lunchtime if you want more information about that. But that kind of gives you some overviews about the sort of thing we think about. So what we've got to right now is that we know we need to make a will. You know, we simply cannot not have a will. We know we've got to make a trust, and we know the sort of trust we're looking at is preferably a disabled person's trust, but if not, a discretionary trust. Either of those two, but if we can upgrade it, then that's going to be great for us. So having safeguarded what happens if we die, we then need to have a little bit of a think about capacity. So capacity in a legal context is the sort of mental capacity, is the capacity to make a decision about something. And it's about the capacity at the relevant time to make a decision about something at that time that relates to that decision. So you guys who had your fourth glass of wine last night, it was whether you had capacity last night at 10 o'clock to have your third or fourth glass of wine. So it's things like that. You're looking at the relevance of the circumstances at the time. Now, capacity is massive. Capacity to make a cup of tea there, the capacity to invest in stocks and shares down there is massive. And what a lot of professionals unfortunately do is read something and it says, we do lots of work with the Down Syndrome Association, for example, and someone will have a diagnosis of Down syndrome and professionals will then say, well, that's it, they don't have capacity to do anything. And that's not right, and you know that with BBS. It's this massive. So what mental capacity is in a legal context is about making sure that people can actually do what they possibly can do, and then we help them do the rest of the things. So mental capacity, from our point of view, was slightly helped in 2005 by the introduction of the Mental Capacity Act, which gave us a bit more foundation about what we need to think about. And the interesting thing is, when this was going through Parliament, it started as being called the Mental Incapacity Act, which is massively negative, and then it dawned on somebody at the last minute to say, well, actually, incapacity, if we're calling it the Incapacity Act, is that not a negative? We need to ramp it up and flip it over. So what the Mental Capacity Act actually did, which helped us enormously, was introduce 5 core principles that everybody, no matter who they are, should be considering when they're working with anybody. The first 3 relates to the individual we're looking at, and the last 2 relate to decisions made on behalf of that person. So the first one is that we always start, irrespective of what the diagnosis is, we always start with a presumption of capacity. So when we're looking at the person, we are saying you have capacity unless it can be proven otherwise. So that flips it onto the positive rather than the negative, saying you don't have capacity unless proven you do. So we're looking at the situation to say, let's say you do have capacity, and if not, well, then what can we do about it? The next thing is that we need to always maximize decision-making capabilities. So that's really interesting because for us, when we're looking at that relates to things like what is, as Sarah said, some of these things, what is the right environment for that child? Are they, as Sarah was saying, are they hungry? If they are, their capacity is going to be wavering. So what's the right time of day to make a decision? Is there medication that affects making a decision? So is there a medication that brings somebody a bit more alert, or is there a medication they take at night time to calm them down? And so that's going to affect capacity. Environment, that's going to affect capacity. Seeing a lawyer in a suit on a Saturday morning has got to affect capacity. So when we're talking about capacity and talking about maximizing capacity, for us, we talk to a lot of our clients and say, well, if you want me to go and see your child and have a chat, do I need to be in jeans and a t-shirt? Absolutely fine, not a problem at all. And do I need to come and see your child at home or in their school or something like that? So thinking about maximizing capacity is really important. Now, that is not as easy as it sounds when it comes to talking to other professionals, because social workers and the like have real limitations on their time, but it is something you need to communicate. We've all got the right to make unwise decisions, and I'm really sorry, I'm very conscious that I'm running out of time, so I'm going to go a bit quicker. I'm going to allude to the person who did confess they had too many wine glasses last night. Did they make an unwise decision? That's in the eye of the beholder. The next thing, so the first 3, we're talking about the individual and about capacity to do stuff. The next 2 is about if we're taking decision for somebody. So the first thing is we need to make every decision in that person's best interests. It's not about us, it's about them, it's about making decisions for them. So whatever beliefs I have is not about me, it's about them. You need to do what's right for them. And we need to take the least restrictive approach. And this comes into play quite a lot when you look at things like deprivation of liberty orders. So what we're saying is if someone's got a behavioural issue, don't lock them in a room, facilitate them to leave the room with help. So it's the least restrictive option. So thinking about mental capacity, we're trying to empower people to do things. If they can do things, there are things like powers of attorney that could help them. But I'm just going to go on very quickly to quarter protection. I'm just going to call this all up because we'll talk about this a bit later on this afternoon, but anyone can find me. The Court of Protection is there as the ultimate body to help protect people who cannot make decisions for themselves. So you only ever go to the court of protection where somebody cannot make a decision for themselves. So when we look at the Mental Capacity Act and look at the presumption of capacity and about maximising capacity, if we can do that to help someone make a decision for themselves, we do not need to go to the court of protection. Where a person doesn't have capacity and we need to make decisions for them, then we might need to go to the court of protection for their help. You've got two things that you normally come up with, or two sort of core principles that normally people come into contact with, and that's being somebody's deputy, either for financial decisions or for health decisions. And I've said there, just be careful to go to the court at the right time. Going to the court is not cheap, it's not quick, it's not easy. It is a court, they do sit. Usually speaking, you don't have to go to them because usually it's a paper-based court, but it is a court structure. Once you've gone to them, quite often you're then beholden to them for future decisions. So quite often you have to go back to them for reporting things. So just be careful about going to the court of protection at the right time. Sorry, I'm really conscious that I'm eating up someone else's time. So just to finish, we've got our typical family there. Mum and dad with a child who's 18 who has BBS. What do they need to think about? Well, what they need to think about is they have got to make a will. They simply cannot not have a will. They then need to think about the trust, because we need to think about the protection of means-tested benefits, the vulnerability, and the capacity-related issues. Then we need to think about, if our child is 18, whether they can actually do a power of attorney. If they have capacity, they can make a power of attorney, and that could make your lives as parents so much easier. But if they don't, we then need to consider whether we need to apply to the Court of Protection for the court's help. So, that kind of brings me nearly dead on the dot to the end. I'm really sorry. That was literally 5 hours worth of chat crammed into 25 minutes. I'm doing 3 slots this afternoon. Equally, I'm around at lunchtime, and we've got some information sheets that will be there for you if you want to grab those as well. Thank you.
Couple of questions.
Is that all right? Have we got time?